And then we're also going to be talking about, and this is actually one of my points for the top 5 reasons, but kind of the next topic we're talking about is minimizing taxes. So a big concern people have when we're talking about, estate planning is, what types of taxes are my beneficiaries going to have to pay? How do I make sure that I lessen that as much as possible and make sure that they don't have to overly, or pay high taxes or more taxes than they otherwise would, just being tax efficient. And so we'll go through the types of taxes that most people are concerned about, the ones maybe people should be more concerned about, and then also how to minimize those taxes. So to get started with our top 5 reasons to complete your plan, and I guess before I dive into that, just a couple reminders, as always with these webinars, they are interactive, so you can send me questions through the Q&A function and I'll see them pop up and I'll answer them as they come up. And then also keep an eye out for an email from us where you'll get a feedback form, which lets you let us know whether or not you'd like us to set up time to talk with one of our attorneys. We schedule those initial consultations for about 2 hours, give or take, and they are complimentary. So if anything we bring up today is a reason you want to come in and talk to one of us, please fill that out and let us know. And then you'll also get a couple handouts as well. So our document finder form, which is kind of a list of where you can set up where, here's where I hold my documents. And so if your family's looking for them, they know where to look. You don't have to give them copies of your documents necessarily, but it's a really helpful tool of, hey, it's in the safe, or I have my will, hopefully you don't do this, but I have my will at the safe deposit box at the bank, things like that. And then from our tax side of things, we're going to be talking, the handout is going to be from, tax changes that have occurred over, the last 40 or so years. So just to give you an idea of, well, these are the types of changes that have happened in the past. And, if it's been X number of years since you've planned or, updated your plan, these are the types of tax changes that you really should be aware of, and how they might impact you. So without further ado, talking about the top 5 reasons to complete your plan. One of the most important things when we're talking about putting an estate plan in place for yourself is making sure that you are taken care of. The person doing the planning is taken care of. So this takes a variety of forms, and a lot of people kind of tend to overlook this part of it because they're thinking about estate plans being, how do I transition things to the next generation, not how do I make sure I'm taken care of. But when we're talking about making sure that you're protected, one of the most important things to be aware of is, what happens if you have an incapacity, if you have a disability or something that happens health-wise, where you can't do things for yourself anymore, where you need someone to step in for you. So when we're talking about this type of planning, one of the most important things to be aware of is whether or not you're using a will or a trust to pass your assets. You should have 4 documents, regardless of those, which type of estate plan you're using, in order to ensure that if you need someone to step in for you, that they have the authority to do that. So those documents are a financial power of attorney, a healthcare power of attorney, a living will, and a HIPAA authorization. So when we're doing planning for someone, regardless of the type of planning that we're doing for them, we want to make sure they have those 4 documents. So, these cover everything. The financial power of attorney covers everything from, can the person go to the bank for you? Can they pay bills, access accounts, right? But it also can extend beyond that to things like, can they engage in gifting? Can they continue gifting that you might have been doing, or charitable giving? Can they sign certain types of legal agreements, right, for you? So no 2 powers of attorney for finance are necessarily the same. Just having one in place doesn't mean you actually have all of the authorities you might need. So it's really important to look at your financial power of attorney and see, hey, what exactly does it say? It's only as helpful to you as the authorities it provides. And one of the biggest issues we see with this document is when people come in with like the statutory form, the one that you can just download from the state of Wisconsin, and it's very, very vague in what it actually covers. It'll say one-word authorities of, my power of attorney can do banking, or they can, do business for me, and you initial next to these authorities. The problem with that, even though the statutes actually talk about what these things are, the problem is the person across from you might read that differently than you do. And so it's really important to make sure that it's very explicit what's in there. Healthcare, obviously over healthcare decisions, you want to make sure that that's in place so that if you aren't able to make healthcare decisions for yourself and you have an unexpected health event, that's the person you would want to make those decisions can do that for you. And then HIPAA, obviously, if you've gone into the doctor's office in the last, I guess 30 years almost at this point, you'd know that you have to have a HIPAA authorization on file so that the doctor can talk to certain people. A living will is where you explain what your end of life wishes would be. So this is different than a DNR order. This is where you're saying, hey, I want to make sure that my agent, my healthcare agent knows what I would want if I'm not going to recover from life support. So you want to have these in place, because if you don't have these documents in place and you lose capacity, then you have to go through guardianship to get them in place. And that can be avoided for most people if you have good powers of attorney. So protecting yourself is all about making sure that you have the planning you would need so that your loved ones can make decisions for you if you can't. Another thing that we talk about quite a bit when we're talking about making sure you're protected is making sure if you have concerns about like long-term care expenses, that you have ways to protect yourself in that event. So what we're talking about with that is making sure that if you are concerned about long-term care expenses, that you have looked into long-term care insurance, for example, as a way to help pay for care. Or if you have concerns about protecting assets, that you've done that effectively. So making sure that you've done that planning. If you have questions about it, talk to somebody who practices in the area of estate planning and elder law. Don't just rely on what you've seen online. Make sure that if you have heard advice from somebody of, I should just gift the home to the kids, that you don't just do that without talking to an estate planning attorney first. Another really big reason to make sure that you've planned around your care or around your estate plan in any given year is, does your plan actually have the intended result that you would want? So a lot of people think, I've got my will done, I've had it signed, my wishes haven't really changed, everything goes equally to my 4 kids or however, and so I'm good, I don't need to do anything else. Well, the problem is whether or not you're using a will or a trust, those documents don't necessarily apply to all of the things that you own. It's really important, whether you have a will or a trust, to make sure that your assets also follow those documents. So with wills, for example, wills only direct probate assets. Well, if you have things like payable on death or transfer on death designations on accounts, or you have joint ownership on an account, those things don't go through probate. They pass directly to the beneficiaries listed or to the other surviving joint owner. Well, if that's not going through probate, your will doesn't direct those assets. And that can be a huge problem for people who are expecting this to be the result that their will has, codified, so to speak. And then the family's expecting that result too. And if it doesn't end up being the final result because accounts weren't titled properly or designated properly, they weren't subject to that probate process, it can cause some problems. And one of the biggest problems that we run into with that is one of like bill paying, for example. So when we're talking about probate, the expenses for that estate come out first before the final beneficiaries receive everything. With probate, once those expenses are paid, the final distribution has to be followed by that personal representative. They have to follow those wishes. But a lot of people will put on their accounts, payable on death to the personal representative because I want them to have access to bill paying. What that does, though, is that makes them the owner of that account. It makes them the beneficiary, and they don't have to follow your wishes. They own that money. Then they don't have to follow the will, but they also might not be able to if they have certain legal liabilities that they're concerned about. So if they have things like creditor concerns or they're in long-term care, for example, what you're essentially asking that personal representative to do as that beneficiary of that account is to gift money out to the beneficiaries that you wanted to inherit. Well, you can't engage in gifting when you're, on Medicaid, for example. That would cause you problems. You can't engage in gifting if you're subject to a bankruptcy proceeding, because that is something that a bankruptcy court would not allow that person to do. It would cause them more liability to do so. So if you have a will, sending assets through the probate process, or at least enough to pay expenses, ensures that, one, your expenses are covered, but also make sure that everybody shares in those expenses equally. They don't just get their share and then the personal representatives begging for these expenses to be paid by the beneficiaries. They have enough to do so. But also make sure that if your intended result was that everybody inherit equally, that they get all of those accounts equally, that they share in those expenses equally, right? That nobody gets more than intended or less than intended because the expenses were covered through, the one person who was acting as the beneficiary and the personal representative. They used more of their share than somebody else. So make sure that if you have a will and your will covers things that you want to happen, it says, well, here's who I want to inherit, how I want them to inherit, that your assets are actually subject to that will. And very similarly, when you have a trust-based plan, for example, trusts only direct assets that they own or that they will own at the time of your death. So you could have the best trust in the world, the most well-drafted trust in the world. And if you have everything go outside of that trust, it's essentially worthless to you. It doesn't help you at all. It doesn't direct those assets at all. And that can be a really big problem if, one, you've spent money creating that plan. And two, if there's protections within those documents for beneficiaries with like unforeseen consequences or circumstances. So that can be a really big concern, especially for children who might have supplemental needs, right? They have benefits that they're on, and the planning that you've done is supposed to protect those benefits, but then you've named them directly on an account. That can cause problems for them. They can have countable assets then that count against them for those purposes. One of the really common concerns that people have, thankfully less common of an actual reality, I think, for a lot of people, but a common concern is what happens if the people I've named on this document, what happens if they have a substance abuse problem at the time, and I wouldn't want them to suddenly have access to all of these funds? Well, a well-drafted will or trust will say something in there about, well, if any of my beneficiaries who inherit from me have that issue, they don't get to have control over those funds. Somebody else will be put in charge of them. And it's supposed to be used for their benefit, but it makes sure that, hey, they're not the one making that decision. They don't have access to it themselves so that they can't cause harm to themselves. If you just name direct beneficiary designations on your accounts to those people, then none of those terms from the will or the trust actually end up applying to that money. So it's just very important when you have an estate plan, or if you have one already, and you're not sure if this is the case for you, to make sure that not only is your estate plan up to date or does it cover those concerns, but also will that actually apply to your assets? Will you actually have protection for those beneficiaries? Because it's just as important to make sure that your assets actually use the plan, that they're designated properly, that they're titled properly. And it's just as important to make sure that that's the case as it is to make sure that the documents themselves cover those concerns. One thing we deal with a lot when we see people come in with old wills is that those wills don't apply to anything really other than their home. And so that means maybe a lot of their wealth or assets aren't being followed properly. The distributions aren't being followed the way they would have intended. So when you come in to have a plan drafted with an attorney, it's really important to really know what is your intended result. What would you want people protected from? What are your concerns? And then make sure that when that plan is crafted for you, that not only are the documents covering what you need, but also that you have somebody who can help you fund that plan. And by fund, I mean retitle accounts or update beneficiary designations. Because if that isn't being done, or if you're not doing that, you might have a really well-drafted document, but not an actual plan in place that will be the end result. So make sure that when you have a plan or when you're trying to get a plan in place, that not only are the documents in place, but that the plan will actually function the way it's intended. If you don't have a plan, though, that can be at all, and you pass away, that can also be a concern. Because the state of Wisconsin has actually crafted a will for all of us. If you don't have one, it's the statutory will. It's what we would refer to as the rules of intestacy, meaning you died without a will. Well, for most people, this might sort of be what they want. Essentially, if it's a first marriage, all joint kids, things like that, it can be pretty straightforward. It says, if we're married and we have all joint kids, no blended family situation. Well, if I die without a will, everything goes to my spouse. And if both of us pass away, everything goes to our kids equally, right? That's what most people want. Where things can get really complicated is with blended families, though, where the rules of intestacy split things differently if there's not joint kids, or if there's that blended family situation, or if there's adult or minor kids. So it's really important, if that's different than what you would actually want to happen, if you would say, well, I know it's a second marriage and we have a blended family, but I really like for my surviving spouse to still receive everything, at least initially, so that they can use it for the rest of their life. Well, that's somewhat different than the rules are under the default statutes. So if that's important to you, if you don't have a plan and that's not what your intended result is, you need to plan around it. You can opt out of these statutes by actually putting a plan in place. So the more complex your family situation is from a standpoint of blended families, second marriages, or later in life marriages, right? You need to be more intentional about your planning than just saying, whatever happens, happens, because it is important to know what are your intended results and do the statutes actually do that for you. For some people it might, but you never ever want to rely on the defaults under the law for you if you are really worried about making sure what you want to happen actually does. So that was kind of point number 2. The first one was protecting yourself. My third kind of top 5 reason was making sure that you protect your loved ones. And I've alluded to this a little bit with things like the substance abuse concerns, or people who have means tested benefits that they're receiving. But you can provide a lot of asset protection for your loved ones that are inheriting from you, whether they have current concerns or you just want to protect against future concerns. Protecting what you leave your loved ones is important. And, that can take a variety of forms, those concerns. We often look at this as protecting someone from themselves or protecting someone from others. So kind of to run you through a couple examples of that, one of the most common reasons we're trying to protect someone from themselves is just being young, youth is a concern. You can legally inherit money at age 18, but maybe you don't want an 18-year-old in charge of, tens of thousands, hundreds of thousands of dollars. You might want to place a higher age on there of when that person could have access to those funds themselves. Not when it could be used for them by somebody else, like somebody older who's more responsible making financial decisions, but that they themselves can't make decisions over it until they reach that age. And, the joke is always, an 18-year-old inheriting someone younger inherits, tens of thousands of dollars, let's say, even not even hundreds of thousands. It's not a matter of if they're going to go out and buy that new fancy car, but what color it's going to be, right? So making sure that they aren't using the inheritance for things like that if that's not responsible. So youth is a big reason, but just general fiscal irresponsibility could be one that you're concerned about. Regardless of age, you might have a child who's in their 50s who's just never been very good with money, and you don't want them to be the one in charge of those funds. You might want to put certain protection in place in the form of, here's who's actually going to be in charge of it, or I'm sorry, son or daughter, but you're not going to be the one in charge of this, and make sure that that's actually enforced. Just general irresponsibility can always be a concern, even if somebody gets to a certain age, right? At a certain point, they may just not be able to handle those decisions. But protecting people from others as well can be a really big concern. So a lot of people worry about divorce, for example, of how do I make sure if this money goes to my son or my daughter, that if they're divorced, they're not going to get any of it. And in general, inheritance is not marital property, but what a lot of people do, like if it was payable on death directly to them, is a lot of people commingle these things very quickly or over the years. And that can be very difficult then upon a divorce to figure out, well, where did this money come from? Whose is it? Is it still part of the inheritance, or is it now marital property because they commingled it? So when you're planning for your loved ones, you can make sure that they don't have the ability to commingle those funds and say, well, no matter what happens, we know that is not going to be marital property, right? They're not going to receive that upon a divorce, or the in-law won't. So one of the first questions I ask people when I see that one of their children are married is, how do you feel about that person? And are you concerned at all about, once they inherit, even not even divorce, but do you not want them to leave anything to that spouse? Do you want it to go to someplace else? And this is also kind of tying back into your intended result of, if you want everything to be kept in your family, to your grandchildren or great grandchildren, you don't want spouses involved, that's a restriction you can put in place. But that also then would protect against, not just divorce, but leaving something to a spouse that you don't like, right? Hopefully that's not your case. I hope everybody's families, get along and you like all your in-laws, but it happens, right? The other thing that, people are concerned about is, my son or my daughter might be perfectly responsible, in good health right now, but what happens if they have a disability down the road, or they have, some sort of lawsuit liability that comes up that, regardless of responsibility, was just something that happened. So an example of, a responsible person potentially being subject to a lawsuit might be a lawyer or a doctor, somebody with a high liability career, right? Business owners. Business owners in particular have high liability and the potential for higher debt loads, potential bankruptcies if the business doesn't work out, right? You might not want the money you leave that person to be subject to those things, and not just because you don't want to, have your money to go towards those sorts of things, but you want to protect the person you're leaving it to so that they can continue to have that money available for their own needs. And these are all things you can protect your beneficiaries from, assuming that those terms are in your plan, whether it's a will or a trust, that you fund those plans properly, you allocate the assets properly. You can protect those beneficiaries from not just things you do know about, but things that could come up later, even if they're not a current concern. So it's really important, whether you're using a will or a trust, to make sure that that document says, hey, even if this isn't a current concern, if my beneficiaries or anybody inheriting from me has any of X, Y, and Z happening to them, my personal representative through the will, or my trustee of my trust, can decide that this is how that person is going to inherit instead. They can't disinherit them on your behalf, but they can say things like, okay, now they're going to have a trust fund set up for them where they're not the trustee, or they're not allowed to be their own trustee at this time if there is already a trust set up for them, those sorts of things. So protecting yourself is important, but protecting your loved ones is kind of the more, so to speak, the more primary goal that a lot of people have when they're coming in to do their estate plan. The fourth thing, and this really ties into what I'm going to be talking about kind of in our next topic, is your plan tax efficient, right? A lot of plans that we see come in from 20 years ago, they might have been really tax efficient at the time, but tax laws change. And so a lot of plans from 20, 30 years ago are talking about things like, oh, I don't want to pay as high of estate taxes. I want to lessen those estate taxes for my kids, my estate to have to pay. Well, that long ago, the estate tax exemption was quite a bit lower, a lot lower, in fact, where it was, in some cases under $1 million for the total value of the estate was the amount you could pass estate tax free. Well, we're much higher than that now. So that planning comes with some restrictions on it for the estate, for beneficiaries, and it might not be as tax efficient as it could be anymore. That we worry about different kinds of taxes now for most people, things like capital gains taxes or ordinary income taxes for certain types of assets. So, making sure that not only is your planning tax efficient at the time, but that if it isn't, that the concerns have changed over what types of taxes that the estate might have to pay or the beneficiaries might have to pay, that your current plan also addresses what the current tax concerns might be. A lot of people too, and this happens a lot with real estate primarily, but it can happen with stocks too, I suppose, is a lot of people ask questions, whether it's because they're worried about nursing home costs or because they just want to transfer things to their kids and make it easier. We get a lot of questions about, should I just gift the home to my kids, right? Should I just put that home in their name now because I know that's where I want it to go, and I just want it to be easier, or for the nursing home side of things, I just want to make sure that it's not available for my care, right? That the nursing home can't eat up the home value. And the problem with that type of planning where you're gifting it to the kids is your home essentially has, or it does have, what's called a cost basis. You have a cost basis in that home. If you're unfamiliar with what that means, essentially, from a very simplified explanation of it, it's what did you pay for your home, right? What did you buy it for, off the market when you paid for it, or what did you put into it if you built it yourself, or and it wasn't already existing? What do you have monetarily in the home? And then when you sell a property like that, the difference between what you paid for it and what the sale price is how they figure out, the IRS figures out what your capital gain is on it and how much in tax somebody might have to pay. Well, with your primary residence, you have every owner of that home, as long as it is their primary residence, they have a $250,000 estate tax exemption, or capital gains tax exemption that they don't have to pay on that amount of gain. So for a single person, as long as they don't have a gain of more than $250,000 from the time they bought it to the time they sold it, they don't have to pay any capital gains tax on it. Married couple has double that, right? So most of us on our primary residence don't pay capital gains tax on the sale of our home unless, we sold it within, 2 years of living in it. But when you gift that property over to the kids, the IRS looks at that as if you said, all right, they paid for it, whatever I did when I initially bought it. So if it's been 20, 30 years since you bought your home, your kids, the cost basis you're transferring to them is very low. And if it's not their primary residence, they don't get that same capital gains tax exclusion that you would. So when they sell it after you pass away, or whenever they sell it, they're going to have to pay 15 to 20%, depending on their own tax brackets, of capital gains tax on the gain between those two numbers, what was paid for it initially and what it was sold for. A much more efficient way to deal with stocks or real estate or anything with cost basis is to make sure that you pass that to the next generation through your estate plan. Make sure it's part of your estate. So rather than gifting it to somebody, it's much better to have it transferred to them after you die. Because what happens then is the IRS says, all right, we're going to adjust that cost basis up to fair market value at the date of death. So that means if I inherited my parents' home and sold it right away, or pretty close in time, I'd have little to no capital gains tax to pay, because the difference between the fair market value and what I sold it for would at best be, minimum, or at worst be minimum, and at best be nothing at all. So it's much, much more tax efficient to pass these types of assets to the next generation through your estate plan rather than to gift it during lifetime. And that's just one example of being tax efficient. But there can also be a lot of planning through, trusts, for example, where your trustee may be able to allocate different assets to different people based off of what is the most tax efficient at that time for them. So, some beneficiaries might be in a much higher tax bracket than others. And if you have a pre-tax IRA as part of your estate plan, but you also have a lot of real estate, your trustee might say, look, for that beneficiary, they'd be way worse off inheriting the pre-tax IRA. So maybe we should allocate these things differently. When you have residuary percentages, like everybody gets 25%, right? That means they get that amount of value from the estate. But it doesn't necessarily mean that every single asset has to be split that way. It can be discretionary in some cases, up to the trustee. And you might actually want them to be able to make those decisions. So tax efficient planning can be, from the best way to get a step up in basis. It can be estate tax planning, but a lot of times it's ordinary income tax planning too. My fifth reason to do your estate plan in 2023 or to complete it is, whether you have one already or you don't have one. If you do have one, has it been a while since you've had your plan looked at and updated? A lot of people think it's set in stone. I did it 20 years ago and my wishes haven't really changed, so I'm not going to update my will. It does what I want it to. Well, if it's been 20 years, laws have changed, tax laws have changed, and I'm sure your family situation has changed too. Maybe they were minors at the time and you have guardians named for your kids and now they're adults and that doesn't make sense anymore. Or new concerns have come up for those beneficiaries that didn't exist at the time, right? If it's been a while, it's a good idea to get that plan looked at again, because you just don't know, what might be available to help with current concerns that you have. But as I sort of mentioned earlier too, if you don't have a plan in place, the biggest reason to get it done is in 2023 or any year is you need to make sure that you're taken care of, that you have planning in place for if you have a disability, but also make sure that you know what your intended result is and make sure that it will actually occur, right? Or that you can, to the best of your ability, ensure that it'll occur. If you do nothing, if you don't have a plan in place, it's really out of your control at that point what happens. If you pass away and nothing's set in stone, you're relying on default statutes, you're relying on beneficiary designations to pass things that maybe aren't your intended result, right? So it's really important to be intentional about this and plan in advance. But okay, I'm not seeing any questions in relation to the top 5 reasons, but our next topic here, moving right along, is on minimizing taxes. So kind of perfect timing on me talking about that. So there's a lot of different tax concerns that people have when it comes to estate planning. Probably one of the biggest tax myths, I suppose, or maybe not a myth, but just a concern people have that maybe most people shouldn't, is one of estate taxes. How much, and how do I make sure my kids don't have to pay estate taxes or inheritance taxes? How do I make sure my estate doesn't have to pay estate taxes? And it really used to be a common issue for people because you see these plans from 20 or 30 years ago where the estate tax exemption was like, $600,000, give or take. And it's gone up substantially since then. So we have a lot of, wiggle room now that we didn't have before in that estate tax exemption. So the good news is now everybody as an individual from a federal standpoint has $12.92 million. So $12,920,000 that they can pass estate tax free. So double that for a married couple. You're, almost at, actually you are close to $26 million as a married couple then. So for most people, that's not as big of a concern as it used to be. If you have that concern, you still have an estate tax concern at that point. It's something to think about, absolutely, because estate taxes are 40%, right? Anything over that exemption is 40% tax. So it can be really a huge tax hit. But it's just not as big of a concern as people have. And I should say, before I go too much further in this, welcome to everybody who's joining us now, at the new topic. And just for those who can't stick around for the whole thing, just a reminder that next week, our topic is going to be on probate. Our webinar, same time next week, will be on probate. And then the 25th down in Oshkosh, we're doing our Wills versus Trust Public Seminar at the Culver Family Welcome Center at UW Oshkosh. So you can sign up for that and watch us talk in a lot more detail about wills, trusts, powers of attorney, long-term care, all of those things. So for anybody who has to hop off, that's a good piece of information and a reminder to fill out that feedback form if you do want to come in and talk to us, just to let us know to set something up. But anyway, back to the minimizing tax conversation. That high exemption now means that estate taxes are not as much of a concern as they used to be. But in 2026, that exemption will sunset. It will go back down to what it was previously with an index for inflation. So, they didn't have enough support to make this increase permanent when that became law, and it only lasted until, through 2025. So starting in 2026, it'll go back. And it was 5 million indexed for inflation at the time. So give or take, this is really going to depend on the inflation that occurs and all of that, but it's estimated to be around 6.5 to 7 million a person. We don't know for sure. It'll really depend on what they tell us it'll be set at, but give or take 6.5 million to 7 million per person. So still pretty high, but not not almost $13 million high. So if that is a concern, that is something to be aware of for estate taxes. You might not have a taxable estate right now, but you might eventually, right? You might, if you're close to that 6.5, 7 million now and you're single, well, one, depending on how young you are, that estate is likely to continue to grow. And we know that that exemption will go back down if they don't do anything at all. They'd have to do affirmatively keep the current exemption. They have to pass a new law keeping that exemption. And, so we're just anticipating that that won't happen at this time because we don't have any information to the contrary. But if you're closer to that 6.5, 7 million a person, and you are trying to do some efficient estate tax planning, it's a good time to consider that, because we do know when that will go back down without, an affirmative change to the law. So take advantage of it while you can too, and talk with an estate planning attorney who can help you figure out the most estate tax efficient way to pass things, for example. But for most people, like I said, this isn't the biggest concern. And even with that decrease, it might not be a big concern for a big chunk of the population. I think right now, the statistics I've seen is the current exemption really only applies to like 0.1% of the population, something like that. It's not a huge amount of people, or a huge percentage anyway of people. But when it goes back down, it will be a significantly larger amount of people than it is currently. Still not the majority, but a larger amount. So the taxes we are more concerned about these days for most people, for pretty much anybody, would be capital gains tax on certain assets. So if you were listening to me talk on the last topic, we talked a lot about the home and stocks for cost basis. Same sort of concern with this. There are assets that have capital gains associated with them when they're sold. So make sure that you are passing those in the most efficient way where you can minimize or eliminate those taxes. So capital gains tax with the home, if you weren't on the last session, just a quick recap would be, when you bought your home, that's essentially what the IRS is going to say your cost basis in that property is. Now, I'm really oversimplifying it. There can be adjustments up and down in cost basis depending on depreciation or capital improvements and the residence, all of those sorts of things. But it's hard to know what that would be for a person's situation without actually going through their tax history. So generally speaking, it's what did you pay for the thing? When you bought the stock, what did you buy it for? When you bought the residence, what did you buy it for? Or what did you pay for it in terms of like construction if you were building it yourself? And when you sell that property, the difference between the sale price and that cost basis is the capital gain or capital loss, depending on the situation. And that's how they figure out how much in capital gains taxes you would have to pay. You pay the tax on the gain. Now, if it's your primary residence and you've lived there for 2 of the last 5 years, then you have a $250,000 exclusion from capital gains tax that you don't have to pay tax on that amount of gain. So for a lot of us, the sale of our home is not taxable, assuming we've lived there for 2 of the last 5 years and it is our primary residence and all of that. But a lot of people with these types of assets, whether it's due to nursing home concerns, costs, protection concerns, or just trying to pass things in an easy way where they don't have to wait until death to receive it. A lot of people ask about, should I transfer the home to the kids? Should I gift this asset over to them? They're not buying it from me. And the problem with that is that's when the IRS looks at that as if you just, transfer that cost basis over to them as well. So they're going to say, well, I know you bought your home in the 60s and your kids didn't buy it in the 60s, but we're going to treat it as if they did. So if you paid $30,000 for your home and you gift it over to the kids, that's what the IRS is going to assume they paid for it as well and say that they paid for it. That's their cost basis. The problem with that can be that if that is not also their primary residence, when it comes time to sell it, whether it's during your lifetime or after you've passed away, they can't claim that exemption from capital gains tax that you can on that residence, right? Because they don't live there. It's not their primary residence. So it's really tax inefficient to say that, I'm going to have you pay capital gains tax, 15 to 20%, depending on their income brackets, on the difference between what I paid for it, 50 years ago and what it's worth today. So you can eliminate that, or at least lessen that need to pay capital gains taxes by making sure that that is passed to them at your death as part of your estate. Then the IRS adjusts that capital gains, or the cost basis, upwards to fair market value at the date of death. It could also go downwards to the fair market value too. It really does depend. But when we're talking about real estate, it's generally going upwards. Upwards at the date of death to the fair market value. So that means that if I inherited property like that from anybody, that I can say that I paid for it, whatever the fair market value was at the date I inherited it, right? The date that person passed away. And so you can mostly eliminate capital gains taxes on properties, assuming that person sells it relatively quickly. If they hold on to it for another 20 years, that's going to be different, of course, but that's different if for different situations. It depends on the property that they're inheriting. If it's just mom and dad's home and nobody's going to live in it, yeah, you're probably selling it as quickly as you can. But when it's things like family farms or cabins or anything that's going to stay in the family for a while, or potentially for more than one generation, those step up in basis. If they sell it later, yeah, they're probably going to still have some gain, but that can be a blueprint going forward too, of making sure that hey, if you are going to hold on to that property for the rest of your life, if it was gifted to you, it's even more of a reason to make sure that you don't gift it to the next generation, that they either purchase it from you, which would not be very tax efficient because now you're paying tax on that, or they inherit it from you. And then you've wiped out all of the capital gains from all of that period of time. So just make sure that when you're doing that type of planning, your intention might be to make it easier on somebody to transfer it this way, but it's really tax inefficient to just gift property over to somebody else. There can be exceptions to this, of course, where it maybe does end up making sense for somebody, but you just need to be informed in it and make sure that you're talking with an estate planning attorney on the best way to do this before you do, listen to what the internet has to say or what your neighbors have to say on it, just because that information might not be as complete as you would like. So capital gains tax, can mostly be eliminated for most people if it's done effectively. But we also, especially right now, are very worried about ordinary income tax concerns for beneficiaries. So inheriting things, just receiving an inheritance is not taxable to the beneficiary in Wisconsin. You don't pay inheritance tax. It's not ordinary income. If somebody just gave me a bank account at their death, I'm not paying tax on that. But some types of assets, specifically pre-tax retirement accounts, those taxes don't go away. You've put money into your 401k or your IRA or 403b or any account like that pre-tax, if it's not a Roth variant of those accounts. You've put it in pre-tax, which means that somebody has to pay the tax on that when money's coming out. So you have to pay tax on that when you start taking your required minimum distributions, right? At 72, for example. And that will start actually going upward with a new law that was passed at the end of last year, eventually up to 75. But that'll take some time to get to that point. But at those ages, you have to start taking money out of those accounts and pay tax yourself on it. But that tax does not go away for any remaining balance in those accounts. So when somebody leaves their pre-tax IRA to their beneficiaries, they have a certain amount of time to take all of that money out, which currently for most people is going to be 10 years. 10 years is the most amount of time that the majority of beneficiaries are going to have to liquidate those inherited IRAs, inherited retirement accounts. So that means that they only have 10 years at most to pay tax on it and do tax planning. There are some exceptions to that 10-year rule. So for example, a spouse is an exception. You get to roll that over as a spouse and treat it as your own. So if a spouse passes away, before required minimum distributions even have to start, that doesn't mean that the spouse suddenly has to start taking all that money out, over 10 years. They can roll it over and then wait until, their required minimum distributions would begin to start taking money out. So a spouse is a really common exception that you've run into. But there's also exceptions for like minor children. It has to be minor children of the original account owner. So, they get a life expectancy stretch up until they're age 18, and then they get 10 years. So, if I guess an 8-year-old received an IRA inheritance from a parent, they would have 20 years to take the whole account out, but they wouldn't, so they'd have to take it out by the end of year 20, right? But they have to take required minimum distributions during those 20 years still, in addition to additional amounts of money if they're doing tax planning. So again, that has to be minor children of the original owner. It can't just be like, I'm leaving it to, my niece or nephew or to a great grandchild or something like that, just because they're minors. That doesn't work that way. Disabled or chronically ill individuals can qualify as an exception to that 10-year payout where they're getting a life expectancy stretch. They do have to be disabled or chronically ill under the IRS definition of that. A really strange exception that is coming up more frequently that I've seen, just because some people don't have kids of their own and they're leaving these types of accounts to like siblings of theirs, is if somebody is not more than 10 years younger than the original account owner when they're leaving it to them, they can get a life expectancy stretch too. So like if a brother is leaving it to a sibling, or one sibling is leaving it to another rather, and they're within 10 years of age in terms of, the younger sibling, then they can get a life expectancy stretch. They have to start taking required minimums right away when they inherit, regardless of age, but they can get that stretch. Now, it doesn't matter if you're more than 10 years older, you're still not more than 10 years younger. So you could be 20 years older and still get that life expectancy stretch. So that is a weirder exception that is applying to some people, but weirder in just it's very, very situational, and it depends on your family situation whether you could use that. But the reason this is a tax concern is it used to be prior to 2020 that no matter who was inheriting, other than spouses, whether you were a minor child, an adult child, or just a random person that somebody wanted to leave money to, that person would get a life expectancy stretch, based off of their age at the time of inheritance. It wasn't 10 years. So, they could stretch that tax burden out a lot longer for most people than they can now. 10 years is much shorter than even, like a 60-year-old would have inheriting that amount of money, or a 70-year-old would have inheriting that amount of money. So, it's compressing the timetable that somebody's gonna have to pay income tax on this. There are things you can do to lessen that tax burden for the beneficiaries. Now, one way to avoid paying tax on it at all would be charitable planning. If you're charitably inclined, this can be a really good way to use your IRA or 401k. Because when you have to start taking required minimum distributions out, for example, if you decide, I don't really need that amount of money, it's just making my taxes go up, but you give to charity every year, you can actually have what's called a qualified charitable distribution made, from that required minimum or in place of that required minimum to a charitable organization of your choice. And then you don't have to pay tax on it. The charitable organization doesn't have to pay tax on it, right? So it can be a really good, efficient way to both accomplish your charitable giving intent and also avoid income taxes. But that charitable giving can also be at death too. If somebody came in to talk to me and said, well, I have, I want about 20% of my estate to go to charity. One thing we might look at is, can we make sure that that amount comes from their pre-tax IRA if possible, as much of that as possible, so that one, we know the charity is not going to pay tax on it, but then the kids don't have to pay tax on that money either. They would be much better off getting, a Roth account or a just traditional investment account or a real estate or cash, right, than they would from a tax standpoint of inheriting a pre-tax retirement account. So, if you're not charitably inclined, though, you don't, and there's nothing wrong with that. You just want to make sure that you're doing some other tax planning instead, because then you're not using those options. And charitable planning can be great, but if it's not your intent, don't do it just to eliminate taxes, right? You want your intent to be followed first and foremost, or you want the end goal to be followed as much as possible. You don't necessarily want to do charitable planning just because you don't want somebody to pay tax on it, because then you're still not giving that money to the people you'd want it to go to, right? So one thing that you can do during lifetime is look into Roth conversions for your retirement accounts. So this is something that you're probably not going to be doing until you're a retirement age, or you're done working, because your income is going to be higher while you're working. But the Roth conversion strategy involves you deciding, I'm going to pay some tax. I'm going to pay the tax on that money and convert it into a Roth IRA. Well, Roth IRAs are post-tax, so beneficiaries don't pay tax on those when they inherit them or when they're taken out. They'll never pay tax on those. They grow tax-free. You don't have to take money out from those during your lifetime, required minimums out. So this is something that can be really tax efficient for you to pay tax on it yourself, but you don't do it all at once. You work with your CPA if you have one, you work with your financial advisor if you have one, to decide how much should we do in any given year. Should we max out our current tax percentage and move some of that this year? Does that make sense to do? So it's not going to be right for everybody, but if it does work for you, you can pay less in tax on it than your kids might. And so some considerations with this are, what is your current income tax bracket, right? Versus what is your children's income tax bracket? If you're retired and you're not even taking Social Security yet, your income might be relatively low compared to your son or daughter who's a doctor, right? They're maybe already in a top tax bracket. So that not only are they in a higher tax bracket than you, but when they inherit that money, they're going to continue to be in a higher tax bracket than you currently are, and they have a shorter period of time to take that money out. So that means that you are not only having them pay a higher bracket, but on more of it at any given time. So that's one consideration when you're looking at this is, hey, if I could pay less in tax on this than they would have to, I'm helping them maximize the value of what they're receiving. I, of course, have some people who say, that's their problem. Then, they pay the tax on it. That's their problem. And, it's something you have to be willing to do, is pay tax on it if this is the strategy you use. But if you can maximize the value and that's your goal, it can be a really good strategy to preemptively pay the tax on it, while you're able to. And kind of an ideal time to do this, there are some early retirees who might be, 60 years old, not taking Social Security yet, not planning to take it for a couple of years. So they're in really low income brackets. Well, that's a really good time potentially to say, well, should I start looking into this? And again, it's not going to be right for everybody, but that's where you get your CPA and the financial planner involved to do that analysis. I know enough to recommend it and know it can be very beneficial, but I leave a lot of that analysis up to the tax professionals or the financial planners. Part of that analysis is just going to be, how much do we do in any given year? Because again, you wouldn't do it all at once. That wouldn't be any more beneficial than you'd think, but it can be a really good tool to look at. One other sort of tax efficient use for an IRA, a pre-tax IRA or 401k, again, really any pre-tax retirement account that I'm talking about, is if you end up needing long-term care and maybe you don't have long-term care insurance, a really good use for that money can be, that pre-tax money can be paying for your care from that. A lot of facilities require 1, 2, 3 years of private payment from you before they would let you live there on Medicaid after you've spent your money down. So one potential tax efficient way to do that is to pay from your pre-tax retirement account. And the reason for that is your cost of care is tax deductible. Once you reach more than 10% of your gross income and medical expenses, you can deduct that from your end of year tax. So if you would otherwise have to pay money on this, or pay tax on this money rather, but you can deduct all of those payments that you're paying for your cost of care from that, that means that you are using that money in the most tax efficient way possible. I mean, nobody wants to go into long-term care generally. Nobody wants to have to pay the money on it. I get that. But if it's something that you need, and that's one thing that you could use to pay for it, and you have other assets that aren't going to be as much of a tax hit to the kids, that's where you want to spend that money from first, because it is tax efficient to do so. With that, I won't talk anymore about taxes for you. I'll let you guys enjoy the rest of your day. But just before I wrap up here, just couple quick reminders that you will receive a feedback form at the end of this, where you can let us know if you'd like to meet with one of our attorneys. Those initial consultations are complimentary, so you're not paying anything to come in and talk to us initially. We can let you know by the end of the meeting really what we recommend or what the cost would be associated with that. But you're not paying to come in and talk to us. And those are scheduled for about 2 hours, just to give us plenty of time to go through these situations and really talk with these, through these situations and issues that are concerns that you might have. And then just a reminder that if you're interested in attending the webinar next week, it'll be at noon next week on Wednesday. We're going to be talking about probate and how that process works, and going through some details on that. If you've not dealt with it yourself and you're just curious about what that would look like, that could be really helpful. And then on January 25th, we will be down at the UW Oshkosh Culver Family Welcome Center, giving our wills versus trusts public seminar, where we go into a lot of detail on things I've talked about today: long-term care planning, wills and trusts, powers of attorney, all of that. And there are 2 sessions for that, 2 p.m. and 6 p.m. And you can sign up for that at estateplanninglive.com. Just hopefully see you down there. And if you really want that information, it can be really helpful for you. So with that, I will let everyone go and enjoy the rest of their day. I'm sure everyone's tired of hearing me talk. So I will let you go and hope to see you guys next Wednesday and then on the 25th.